record 584-068. Appearances, please.
Good morning, Honor. Romeo Perez, Monterey 223 on behalf of Rosario Rivera, Bassett. She's present.
Thank you.
Veronica Valentine, bar number 1634 for the defendant, who is also present.
And bar Robert Luke, bar 1489, I'm assisting Ms. Valentine today. I'm representing Mr. Bassett in a related domestic violence case.
Okay. All right. We're here today on the defendant's motion, which I have reviewed. I did get a response recently that I've also reviewed from the plaintiff. So,
Yes, Your Honor.
who's arguing?
Just to remind everybody, my motion was filed on April 18th. I was served with the opposition on Monday. We all know that Monday in the law office is very hectic. I really had no chance to do anything. I did, though, get, and I already gave Romeo, his complete medical record, if you can put it on the left side of the file, showing he's not HIV positive and he has no diseases. So if I can give it to the
Sure.
court.
Do you want me to put it in the confidential? I'm happy to put it in confidential.
It's confidential. He has
Okay.
it. Now, we spoke outside. On May 18th, finally, after much, there was the visit at the home to see his property, to get his belongings. There were two police officers and his mother, a very nice lady, which I talked to. Wife did not allow him in. The story is that he was shouting, he was not at all. His mother will testify, it didn't happen. She told the cops, two cops, he's not coming in here. Everything is in the garage. And the problem is, he did not come there with the intention of taking pictures of the wall. He wanted his stuff, his personal clothes and stuff.
Was it in the garage?
Well, we don't know, he does not know if she put everything in the garage. She put...
Did he take what was in the garage?
No, let me explain. He couldn't take the pictures because he lives in an apartment. Why would she
What
take stuff
pictures?
off the
Why
wall?
are we talking about pictures? I'm lost.
That's when, okay, hear me out. When he came in the garage, she had taken pictures of the wall, his pictures.
Oh, and put them in the garage.
In the garage.
Okay,
He
I missed
lives in an apartment. It was not his intention to take pictures of the walls.
Okay.
But she controlled the situation. She only allowed his mother to go in for a quick review. He never went in. So it was not the kind of transfer or visit for property that we anticipated. It was done in bad faith. In addition, we were here before, Your Honor, on a CMC, and I brought up the issue of the jewelry. There is a lot of expensive jewelry. To today, we have not been able to know what's in that box. She controls the box. I cannot get them to meet me at the bank so we can go look at it, photo it, so he knows what's in there and what's missing. We are talking about very expensive jewelry. Complete control since the case started. She has it. Now the story is, even though when we were here last time, Romeo said it's probably his separate property. Today, it's become community property. If you look at the FDF she filed on Monday, the jewelry says it's both. Romeo tells me today it's community property. Your client has to prove it separate. We are intending to prove it. But even their position about the jewelry has shifted because possession is 9/10 of the law. And you can really see it happening in real time here. So this is one thing. The HIV claim, I think it's put to rest with the medical records, and I think Bob is going to talk about the TPO issue, that my motion is also to dissolve the TPO.
Your Honor, been doing this a long time, and obviously domestic violence is a concern, but the incident that happened in January, which gave rise to the TPO, was a one-time transitory incident at best.
Well, and your client agreed in the February hearing to extend the protective order.
Well, yeah, we didn't represent him, and I'm looking at the situation now that This is not a recurring coercive control and violence pattern, and it was a one-time issue. He's out of the house. There is no risk of domestic violence occurring after this. Now, what he did at a later time, on March 19th, the order provided that he could get his personal belongings out of the house with police assistance. Okay? And so what he did was he went to a place near the house, called 911 at 3:32 p.m. Or 3:34 p.m. From his cell phone, and said, "I want police assistance to go into the house to get my belongings," and that's what he was doing. She works as a school teacher at the Western High School, and come home's about that time, so he was not going to try to do anything. He was in his car just waiting for the police to arrive. At 3:39 p.m., so just a few minutes after he called for police assistance, she came home, saw him there, parked in his car, and then she went berserk and started chasing him around at a high-speed chase. He's trying to stay away from her, and she's chasing him with her vehicle. He's on the phone again saying, what's going on here, and, to the police, and the police came and, of course, they detained him and they detained her. They detained him because he was technically within 100 yards of the house, when he called the police. And that to me, in other words, he didn't try to break into the house, he didn't try to trash the house, he didn't do any vandalism. He stayed in his car just waiting for the police to come, and then they apparently arrested her too, right, at an incident because of her reckless driving and pursuit. So this is not a woman who's afraid of him. This is not a woman who's creating where he's harassing her, stalking her, or anything like that whatsoever. The day that this matters happened back in January, there was just some arguments at home, but that day, he also took her car down to a big old, a discount tire shop to get a tire repaired during the day, and she was with him, right?
My father too.
And his father too was with him. Then he came back and they were meeting somebody from CenturyLink installing Dish Network, excuse me, installing a TV set and all that, and the satellite dish stuff. So all of a sudden, when he come back at a later time, all of a sudden there's a whole bunch of police cars there, but there was no hitting, no nothing. I mean, it was just.
Are you re-arguing the issuance of the protective order?
What I'm saying is this. This was not a real violent incident. I mean, it was just
No, it was a
kind of a
stipulation.
dust-up.
It was a stipulation by your client to extend the protective order.
Well,
and I need a legal basis at this point in time to undo that stipulation, and I'm not hearing it.
well, what I'm saying is that we think the stipulation was ill-advised because there was no ongoing problem, and that it was really not necessary to do that. I've had a lot of TPO cases, and I've been attorneys on, and for the most time on these transitory things, they issue a TPO for 30 days and that's it. I think he got bad advice to stipulate to having it extended for a complete year. That's only reserved for the most serious cases. This was not a serious domestic violence case.
So why wasn't an objection filed timely to his stipulation? Because I have to apply a different standard now than I would have of the objection. Objection would have been clear error, and there was no objection filed. The TPO was put in place. It's been in place for some time.
We weren't his attorneys at the time.
Well,
Okay.
That's not a legal basis.
I understand, but on the other hand, was there a legal basis to extend it for a year other than a stipulation? And the answer is no. There was not enough evidence to justify extending it for a year.
Right, and that's the point I'm trying to make. This argument on an objection, I think, holds water. I don't know that this argument this far down the road on a motion to modify holds water. Because your client agreed to the extension, there was no objection to the agreement to the extension, and now we're coming back saying it shouldn't have been issued to begin with. Well, that's not a basis for me to modify.
I'm not saying it shouldn't have been issued to begin with in January, okay?
I thought
Okay.
that's exactly what you're arguing.
Well, what I'm saying, no,
Okay.
here's what I'm saying, okay? I have attended several continuing education courses on domestic violence over the course of my career. I've, been down here, I've been a hearing master and so forth. There's a differentiation in what we call types of domestic violence. The one-time dispute or the people get, because anger boils over is one type. It's called transitory or situational domestic violence. Then there's the patterns of coercive controlling violence, separation instigated violence.
What
and
I'm
the
looking
like.
for is a legal basis to grant the relief that you're requesting. That's
Okay.
what I'm looking for.
The legal basis is that it's no longer necessary and it's no longer appropriate.
Circumstances have changed.
Circumstances have changed.
What circumstances have changed?
He's out of the place, he has his own place to live, he does not live
He
there.
had his own place to live at the time the TPO was entered. What's the change?
Well, he had to move out. He was still
He was
living
out at the time that the TPO was entered.
at back in
The
January.
extension, no, in
No, at
February.
the extension.
Yeah. At
Well,
the
yeah,
extension
yeah.
hearing, that's not a change of circumstance. He was out at the time of the extension hearing.
Right, but then the question is there a reason to keep it in effect for the rest of the year? And that's what my concern
But that decision
is.
was made back then. That's why we keep going in circles. I have to have a legal basis to grant the relief that you're
If
requesting.
I can offer.
No, counsel, let me finish.
Yeah.
I have to have a legal basis to grant the relief that you're requesting. And what you're telling me is that it's no longer necessary, which indicates to me that there's been a change of circumstances that's occurred since the extension of the protective order. And the question I still have is, what is that change? Him being out of the residence is not a change because that existed at the time of the extension hearing. So is there another change of circumstance that would warrant me modifying?
Well, I'm not sure what you're looking for in terms of change of circumstances.
I'm looking for law. I can't just do it because he wants me to. I have to have a legal basis to modify the protective order.
Okay. The
And arguing that it shouldn't have been issued to begin with is not an argument I can accept at this stage of the litigation.
May I
Okay.
suggest, yeah, clearly what happened was ineffective assistance of counsel. That lady attorney told him to do it for no reason. Today I have no clue why she would have told him to do it. Total ineffective assistance of counsel.
So why wasn't an objection filed timely?
Because he still had her. He had her. She was his criminal attorney, and she told him, "You have to, don't oppose it." She said, "Well, it's their own discussion. I don't know if I can disclose it, but she recommended to him that in order to get his criminal case better
Okay,
served,
how is he being affected negatively by the existence of the protective order?
he can get his jewelry, he can get his
Sure
stuff.
he can. Counsel, I've made those orders. That's not a basis.
One more thing.
What's that?
You have a green card, right? You know that violation of a TPO is an express grounds for deportation.
Okay.
It puts him in a severe risk.
If he
because-
violates.
Huh?
If he violates.
Yes, for a whole year, for unnecessary TPO that he received for ineffective assistance of a criminal attorney that puts him in a risk, that puts him away from seeing what property is there. This man had expensive property at the home, and to today, with all the attempts between both attorneys, we could not accomplish him getting in the house, Your Honor.
Okay.
So, yeah,
All right. I think I understand.
I'm
Yeah,
sorry
and then
about.
no. I substituted into the criminal case last week,
Okay.
and then we're proceeding with that, and so forth. So that's
Is the
That's-
criminal case related to the TPO?
the
It's the
incident on
violation.
March 19th. It was a matter where he was arrested for violating the TPO.
The incident that you were talking about when they were driving around the
Yes,
neighborhood?
Yeah, right.
That's the criminal action.
Right.
Yes.
Okay.
That resulted in a criminal complaint.
So it is related to the TPO?
It's related to the
Got it.
TPO, and in the Justice Court, what I did is yesterday issued a subpoena to the Communications Division of Metro to get the 911 calls and the
that he
radio
called.
traffic and everything else that transpired that day, because I think it would show that he's the one who called the police initially to make arrangements to get in, and that, you know, to access his property. And that would be why he was there at the house, in his car. And so, we
Was
just
he within
don't,
100 yards of her house?
well, I don't know what the exact distance is, but it was close to the house. But it was, because she lives in a cul-de-sac, and he was parked in the cul-de-sac, away from her house, but
Okay.
not,
Potentially
it may
could
be may have been less than 100 yards, but it was off the main street. He was in where, you know, where he could just park, and he called the police to wait for them.
No, I
He
understand.
was on the phone with the police when all
This
this
is the third time
happened.
I've heard that, so
Yeah.
I don't need to hear it more than once. Okay,
Okay.
thank you. Mr. Press?
Really not sure where to start. Judge, as far as striking the tort, certainly we provided enough evidence in our exhibits that show that he's being treated for HIV, he's being treated for STDs. They were married for the last 8 years, and there is at least a risk of harm to my client. My client has been testing to make sure that she's clear of some things, she's not clear of some things, which we will ferret out at trial. But we have provided enough information, I believe, to overcome the summary judgment motion being presented. I think that the TPO, there's no legal basis, and more importantly, and maybe just as importantly, is he continues to violate, Judge. We have written statements by people who are neighbors who say that they see him come by. There's a picture in our exhibit showing his vehicle driving by the house. He just continues to come by and torment her. He's also been arrested for violating the TPO and arrested for being close by when he was represented by counsel. Mr. Rhodes and I worked on trying to get this case resolved very early on, Judge. It is true, and they seem to be focused on this jewelry. And counsel and I have had this discussion about jewelry, about paintings, about clothing, and the only thing he seems to be worried about is the jewelry, and that's fine. My client early on in the case, and we talked about it last time we were here, had boxed up all of his stuff and put it in a storage unit at her cost. And we still working with Mr. Rhodes, trying to get him to reimburse, trying to get some money. For a while, I think he did pay like half the house payment and some other things, but hasn't paid any money since. So she went at great expense and time to move all his stuff to a storage unit, which he was given access to and a key to that he came to my office to pick up. He could have taken it then. Then he asked her to move some of that stuff back to the garage. She then makes all of his stuff available in the garage, and there's still stuff in his garage because he refuses to take it. It is true that his mom did come by, which my client gets along with very well. She came into the house, they talked about the paintings, then they leave, mom comes back, and for 2 hours helps her put the paintings back in the house because they didn't want them in the garage. She thought they were gonna take them because she said he wanted the paintings. Why is he leaving things at the house? Why are we still complaining about this, Judge? He showed up with a truck. He showed up with the ability to move all this stuff and yet refused to take it. It's just a power and control thing. It comes back into the TPO, which is the power and control. I have also taken CLE classes about DV, and I understand power and control and the manipulation. He just wants what he wants and not necessarily what is supposed to be done. He wants access. He was given access. He arrives to the house and starts screaming at her in Portuguese. The police had to tell him to calm down and would not let him go into the house. The police told him, you need to calm down, and had to escort him off. And that's why mom went into the house. Not because my client didn't want to let him in, but because the police said, this is too volatile. We're not gonna do this. You need to calm down. Now, I guess I'm gonna have to get the police subpoena to be here for trial just to discuss that issue. But he didn't even take what was available to him. So I don't know what the problem is. As a matter of fact, his mom tells my client the only thing he's missing is a pair of pants.
Your Honor,
We're
can
good.
I respond?
No, I'm not done.
When you're done,
So,
can I respond?
so-
Of course you can, counsel,
Thank
have a
you.
seat.
So Judge, he was able to enter the house. There is enough evidence to overcome the summary judgment being requested. I know that we've provided that he's being treated. He's obviously, was obviously running a different lifestyle outside of the marriage and was having a relationship outside of multiple relationships, I don't know. The fact of the matter is my client was always in danger anytime they were together. And she was not aware that he was out there being promiscuous, living another lifestyle, endangering my client. and I believe that we've overcome the summary judgment. Judge, I think we're definitely in a position now where we can ask for attorney's fees. We've provided the house available to him. We've showed that he has, there is at least enough information to talk about him being treated for AIDS and treated for being given other medications. We have successfully defended the TPO because there's no basis in law, and he continues to violate it, and he's been arrested during this time. And while he was represented, he goes to the house and creates all these problems. I think we're in a great position here to ask for attorney's fees, and we'd ask for that at this time as well.
What about the jewelry?
Just the jewelry my client has put in a safe deposit box at a bank. She has provided for me pictures, she's made a list for me. I've provided 16.2 to Miss Valentine this week. The jewelry, my client has an obligation to safeguard all of the property. And she's doing that. She's actually, at her expense, gone out to get safe deposit box to put all this jewelry in. That's better than most of my clients. So to say that there's a danger that she's holding things hostage, that's absolutely not true. She's doing exactly what she needs to do, and we will get that list and photos to her. That's not a problem. But there is a community aspect to it, so she should be able to protect her interest.
All right, thank you. Ms. Valentine,
Your
you have
Honor,
something else?
one of the first thing I told you this morning is the motion was filed on April 18, they waited till Monday. So I was not able to reply. I need to reply. The pictures of the cars that allegedly is his in the neighborhood is not his car. His car is gold. So that's not his car. It's a lie. It's a simple lie. He was not in the neighborhood. That's not his car. The alleged affidavit from neighbors, she had a major barbecue a few days ago, and for the neighbors to tell them about the case. And by miracle, the neighbors are now writing reports in June that he's there violating a TPO. This is bad fact. He wasn't there. The neighbors are just, maybe they were drunk, they were having a barbecue, and the reason he knows about this is a neighbor called him and said, do you know that your wife is having a major party about you at the home? It's a barbecue. Now, the medical records that I gave you don't say he's treated for HIV. It says he's negative. It's a big difference. And I never received any shred of paper from Romeo with a list of the jewelry, with photos of the jewelry. Why is it that the jewelry has to be under the complete control of the plaintiff? Where is the logic of it? So the jewelry has to move to an independent third party. That independent third party will take photos and make a list, and then we'll arrange both sides to go visit it. But it should not be in her safety deposit box.
All right, with regard to the issues that are before me today, there was a request, although there was no oral argument with regard to that, with leave to file a counterclaim by the defendant. Certainly that leave is granted. If he wants to file a counterclaim, the court will permit that to happen. As far as the request to strike paragraphs in the complaint, I didn't have a legal basis to strike paragraphs in the complaint, so that request is denied. With regard to the request for a summary judgment determination on the tort claim, the standard is whether there's a genuine issue of material fact. The court finds there's still an issue of material fact with regard to the tort claim, so the request for summary judgment is denied. As far as a request for a date and time to get his belongings, my understanding, and it seems to be consistent on both sides, that he's had an opportunity. He's concerned that he has an opportunity to go into the house. I'm not sure that was part of the agreement getting us to this point in time. Certainly if there's personal items he's still lacking, I have quality counsel on both sides of this case that certainly make sure he gets his personal items. As far as the jewelry is concerned, I need the information. I anticipate it would happen between the April 24th CMC and now to be exchanged with regard to what is or is not in the safety deposit box, so that Dad can be in a better position to decide what is or is not missing in this case. But I don't find the need to spend additional funds and put the items with a third party until that information gets exchanged. It sounds like it exists, so I'm anticipating that that information will be exchanged before Friday of this week, so that everybody's on the same page moving forward. Certainly there are discovery mechanisms in place to obtain most of the relief that the defendant is requesting at this point in time, and the court is suggesting that those discovery mechanisms be utilized rather than continue to come back to the court. With regard to the request to dissolve the TPO, based on my discussion with Mr. Luke, I need a legal basis to dissolve the TPO at this point in time. The only one that I did hear is that it's not necessary anymore, and since we've got a criminal action pending with regard to a potential violation of that, I'm not sure that the court has sufficient information to dissolve the TPO. The TPO will remain in place. I will, however, have the request to dissolve the TPO be part and parcel of the evidence that's presented at the time of the evidentiary hearing that we have set in September to make that determination at that point in time. As far as attorney's fees and costs, while the majority of this, the relief from today did favor the plaintiff, the counterclaim for attorney's fees was not timely, so that's not appropriately before the court today. So the request for fees is going to be denied today. Certainly fees is going to be an issue that I'm taking evidence on as well for the September trial. I think that's all the issues that were before me today, unless counsel's aware of something
I
I've left
just have
out.
a question.
Yes, ma'am.
Did you say the list and photos of the jewelry by Friday?
Yes.
Okay.
Is that tomorrow?
Yes, it is. Yeah. Sorry, I was thinking we were earlier in the week, but that is tomorrow.
Can we get till Monday?
I thought you said you'd already sent it, so I didn't think that was a problem.
Yeah, he told me already sent
All
it
right,
too.
tomorrow's fine.
Great. Any other issues that were pending that I haven't resolved?
A question.
Yes, ma'am.
The TPO issue that is saved for trial, is this why the original TPO was even granted, or just the extension?
The motion before me is to modify or dissolve. That's the motion that I'm holding.
No, I understand. So you're talking about the issue of ineffective assistance of counsel, which led him to stipulate. Is that the issue that you want us to
That
prove
issue
at
was only
trial?
argued orally today. That wasn't an issue that was before me today. Whatever legal basis or factual argument you want to present with regard to the TPO, I will hear at the evidentiary hearing.
Okay.
All right,
Okay?
okay.
All right. Good luck.
She isn't now. That's the law.
She did. And then